Get ready for the dictation in 3, 2, 1, start. It is true, as observed by this court in Shiv Dev Singh versus State of Punjab AIR 1963 SC 1909. There is nothing in Article 226 of the Constitution to preclude the High Court from exercising the power of review which inheres in every court of plenary jurisdiction to prevent miscarriage of justice or to correct grave and palpable errors committed by it. But there are definitive limits to the exercise of the power of review. The power of review may be exercised on the discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the knowledge of the person seeking the review or could not be produced by him at the time when the order was made. It may be exercised where some mistake or error apparent on the face of the record is found. It may also be exercised on any analogous ground, but it may not be exercised on the ground that the decision was erroneous on merits. That would be the province of a court of appeal. A power of review is not to be confused with appellate power, which may enable an appellate court to correct all manner of errors committed by the subordinate court. Now, it is also to be kept in view that in the impugned judgment, the division bench of the High Court has clearly observed that they were entertaining the review petition only on the ground of error apparent on the face of the record, and not on any other ground. So far as that aspect is concerned, it has to be kept in view that an error apparent on the face of record must be such an error which must strike one on mere looking at the record and would not require any long drawn process of reasoning on points where there may conceivably be two opinions. We may usefully refer to the observations of this court in the case of Satyanarayan Hegde versus Mallikarjun AIR 1960 SC 137, wherein K.C. Das Gupta, speaking for the court, has made the following observations in connection with an error apparent on the face of the record. An error which has to be established by a long drawn process of reasoning on points where there may conceivably be two opinions can hardly be said to be an error apparent on the face of the record, where an alleged error is far from self-evident, and if it can be established, it has to be established by lengthy and complicated arguments. Such an error cannot be cured by a writ of certiorari according to the rule governing the powers of the superior court to issue such a writ. In the case of Haryana State Industrial Development Corporation Limited versus Mawasi 2012 7 SCC 200, the Honorable Apex Court at paras 28, 29 and 30 held as under in Mohan versus Most AIR 1954 SC 526. The three-judge bench referred to the provisions of the Travancore Code of Civil Procedure, which was similar to Order 47, Rule 1 CPC, and observed AIR P 538 para 32. It is needless to emphasize that the scope of an application for review is much more restricted than that of an appeal. Under the provisions in the Travancore Code of Civil Procedure, which is similar in terms to Order 47, Rule 1 of our Code of Civil Procedure 1908, the Court of Review has only a limited jurisdiction circumscribed by the definitive limits fixed by the language used therein. It may allow a review on three specified grounds, namely discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the applicant's knowledge or could not be produced by him at the time when the decree was passed, mistake or error apparent on the face of the record, and for any other sufficient reason. So, stop. Thank you.